Hello everyone! Learn with us as we study Chapter 3 of Book 4 of the Civil Code of the Philippines, Obligations and Contracts. Chapter 3 is all about the different kinds of obligations and its classifications under the new Civil Code. However, in this video, we will only study the three sections of the primary classifications. Under the primary classifications, we have the pure and conditional obligations, obligations with a period, and alternative and facultative obligations. Before we dig deeper into these pages, let us briefly define what these terms mean. The pure obligation is an obligation which is demandable at once, while conditional obligation is an obligation whose fulfillment or extinguishment depends upon a future and uncertain event. While the obligations with a period in section 2 is an obligation whose fulfillment or extinguishment depends upon a future and certain event. While alternative obligation in section 3 is an obligation which involves multiple prestations, but debtor will only perform one prestation. Facultative obligation is an obligation which involves a principal prestation and a substitute prestation. Now proceeding to section 1, pure and conditional obligation, this corresponds with Article 1179. It states that in every obligation whose performance does not depend upon a future or uncertain event or upon a past event unknown to the parties is demandable at once. Every obligation which contains a resolutory condition shall also be demandable, without prejudice the effects of the happening of the event. Now, to expound the definition of pure obligation, an obligation whose performance does not depend upon a future or uncertain event, or upon a past event unknown to the parties, and which is demandable at once, there is nothing to exempt the obligor from compliance therewith. Example, if I oblige myself to deliver a certain item to a person without any conditions attached, without any period, this is a pure obligation. Moingon ako nga, ako ni ihatag nimo. Wa giingon kanus or any conditions related to that certain obligation. Consequently, the obligation is immediately demandable. Now, conditional obligation. Conditional obligation is an obligation where the acquisition of rights as well as the extinguishment of loss of those already acquired shall depend upon the happening of the event which constitutes the condition. Now, what is a condition? Condition has been defined as every future event and uncertain event upon which an obligation is made to depend. It is a future and uncertain event upon which the acquisition or resolution of right is made to depend by those who execute the juridical act. The Supreme Court has held that when the obligation assumed by a party to a contract is expressly subjected to a condition, the obligation cannot be enforced against him unless the condition is complied with. Furthermore, the obligatory force of a conditional obligation is subordinated to the happening of a future and uncertain event, so that if that event does not take place, the parties would stand as if the conditional obligation had never existed. So if I have an obligation under a condition nga ako na i-fulfill, if that certain condition is met, ingana nga future event or uncertain event. Pero in any circumstances nga kana nga future or uncertain event kay dili mahitabo or dili moabot, the both parties would understand nga ang conditional obligation mura siya wala na ni-exist. Kay dili naman nimo ma-fill ang condition due to the future uncertain event nga wala ni-abot nimo. In relation to this are the classifications of conditions. The first one is as to the effect of obligation. We have the suspensive condition. What is suspensive condition? It is the fulfillment of the condition results in the acquisition of rights arising out of the obligation. Jurisprudence teaches that when a contract is subject to a suspensive condition, its birth or effectivity can take place only if and when the event which constitutes the condition happens or is fulfilled. And if the suspensive condition does not take place, the parties would stand as if the conditional obligation has never existed. For example, ang papa ni promise na ho nga iya kong tagaan o kotse if malatin owner ko. Mo na ang condition sa akong papa if malatin owner ko. Pero inig-abot sa time, dili na ho ma-reach ang Latin owner, ang obligations ang papa nga ihatag ang kotse na ho is dili na niya need i-fulfill. Kay wala man na ho na meet ang conditions para iyang i-fulfill ang iyang obligation na ho. The second one is the resolutory condition. The fulfillment of the condition results in extinguishment rights arising out of the obligation. So, in any circumstances, nga malatin honor ko, unya naa na ho ang kotse due to his promise or his obligation nga iyang gikuan sa iyang kagalingon ihatag na if malatin honor ko, his second condition would be for me to pass the board exam. Pero if dili na ho mapass ang board exam according to our agreement, ahong iuli ang kotse. Mo na ang resolutory condition. Naana na ho na nakoy rights pero ma-extinguish na siya tungod kay wala na ho na meet ang condition. So, as to the effect of obligation, we have the suspensive condition and the resolutory condition. To differentiate the two, suspensive condition is if the suspensive condition is fulfilled, the obligation arises or becomes effective. While the resolutory condition, if the resolutory condition is fulfilled, the obligation is extinguished. If the suspensive condition is not fulfilled, no juridical relation is created. If the resolutory condition naman is not fulfilled, the juridical relation is consolidated. And in a suspensive condition, rights are not yet acquired, but there is a hope or expectancy that they will soon be acquired. In resolutory condition, rights are already acquired, but subject to the threat of extension. So, mo na to ang example kanina. The second classification of condition is as to the origin of condition. We have the potestative condition. It is when the fulfillment of the condition depends upon the will of one of the parties. So, for example, ako, moingon ko nga, aho kang palitan og relo o muadto ko sa mall. Mao na ang potestative condition. Only if muadto ko sa mall, mapalitan ka na ho og relo. Ang casual condition is the fulfillment of the condition depends upon chance and or upon the will of a third person. So in relation to potestative condition, makaadto ra ko sa mall if dili moowan karong adlaw. Naanay third person involved. Ang will sa one of the parties is maapektuhan sa will of a third person. While ang mixed condition, from the word itself, mixed, is a mix of the potestative condition and the casual condition. The fulfillment of the condition depends partly upon the will of a party to the obligation and partly upon chance and or the will of a third person. It's like a combination of two kanina. Nga, og muadto kog mall, mapalitan ka na og relo. Pero, makaadto ra ko og mall, og dili siya muuwan karon. Muna siya ang example sa mixed condition. Now, what is the rule in a mixed conditional obligation? The existing rule in a mixed conditional obligation is that when the condition was not fulfilled, but the obligor did all in his power to comply with the obligation, the condition should be deemed satisfied. So, even though dili ko makaadto og mall kay kung tahay ni uwan karong adlaw, pero I was still able to buy you a watch through online, or in any case, na fulfill gihapon na ho ang obligation pero not with the conditions. Pero this will consider satisfied. The condition will be deemed satisfied tungod kay nahatag gihapon na ho napalit o nahatag gihapon na ho ang relo pero dili adto sa mall kay tungod kay niuwan lagi nga nang adlaw. The third classification of condition is as to possibility. We have the possible condition and the impossible condition. The possible condition is the condition that is capable of realization according to nature, law, public policy, or good customs. Ay, mao ni ang mga conditions nga ma-realize nimo or matuman nimo tungod kay possible siya through nature, law, public policy, good customs, or maayo ang kondisyon nga ni mga aspects. Well, in contrast to that is the impossible condition. The condition is not capable of realization according to nature, law, morals, good customs, public order, or public policy. It may either be tungod kay sa physical, that is contrary to the simply due to the law of nature. Moora na siya ang sa physical. Or through legal, that is contrary to law, morals, good customs, or public policy. Mo ni siya ang duha ka kinds nga nung impossible nga ma-realize nimo ang condition tungod kay either physical or legal. Now, the fourth classification of condition is as to mode. We have the positive condition and the negative condition under the fourth classification. The positive condition is the condition involves the performance of an act, while the negative condition involves the non-performance of an act. And the fifth condition, or the classification of condition, is as to divisibility. The divisible condition is the condition is susceptible of partial realization. Or ug utang pagani, pwede nimo siyang data-datahan. Pero sa indivisible condition, the condition is not susceptible of partial realization. So you have to fulfill the condition or to realize the condition as a whole or buo siya. Dili siya pwede nga kanisa laman nga part before sunod na ang uban. So dili siya pwede nga na sa indivisible condition. So for the sixth classification of condition is as to numbers. We have the conjunctive condition. There are several conditions, all of which must be realized. While the alternative condition, there are several conditions, one of which must be realized. So sa usa ka obligation, nag-attach siya og several conditions, pero sa conjunctive condition is kinahanglan tanan ang imong ma-meet. While ang sa alternative condition is usa ang kinahanglan nimo nga ma-meet. Well, as to form, or the seventh classification of condition, is the express condition, which the condition is stated expressly. Like imo yung gisulti og unsay angay buhaton, or state jud niya into words or written nga mo na ang conditions attached sa inganing obligations. While we also have the implied condition, which is contrast to express condition, mo ni ang condition that is tacit or nonchalant. Like more understandable na siya nga mo ni ang conditions nga need mo ma-meet without the need of stating it. So those are the 7 classifications of conditions. We had the as to the effect of obligation, as to the origin of condition, as to possibility, as to mode, as to divisibility, as to numbers, and as to form. Now we also have Article 1180, which is still under Section 1 of Chapter 3. Article 1180 states that when the debtor binds himself to pay when his means permit him to do so, the obligation shall be deemed to be one with a period, subject to the provisions of 1197. Period is a time of definite length. Definite, having distinct or certain limits. Determinate in extent of character. Limited, fixed as definite period. Examples of phrases similar to when his means permit him to do so in Article 11.18 is kanang mo yung when I have money. For example, mangutang ka. Inya mo yung bayaran na ka na ho, inigna na ko'y kwarta. Another one is, as soon as I have money, bayaran na ka na ho, inig na ana ko'y kwarta. Bayaran ka na ho, dayon. Nya, when I can afford to pay. Bayaran ka na ho, if kaya na ka na hong bayaran. In connection with the above article, the provision is material to it. In Article 1197, if the obligation does not fix a period, but from its nature and the circumstances it can be inferred that a period was intended, the courts may fix the duration thereof. While the court shall also fix the duration of the period when it depends upon the will of the debtor. In every case, the court shall determine such period as may under the circumstances have been probably contemplated by the parties. Once fixed by the courts, the period cannot be changed by them. If naay obligation nga wala gi-state nga need niya o period to fulfill, pero from the nature and the circumstances kinahanglan nga ma-fulfill na niya nga nga time, the court may fix the duration. Pwede mo decide ang court. And it is also possible nga the court shall also fix the duration of the period when it depends upon the will of the debtor. If mo'y gusto sa debtor. Unya sa tanang instances nga ang court mo'y decide sa period, dili na ni siya pwede maotro once nga ma-fix na ang decision sa court. Next is we have Article 1181, which will be tackled by my groupmate or your other study companion. So, yeah.
So let's proceed to Article 1181. In conditional obligations, the acquisition of rights as well as distinguishment or loss of those already acquired shall depend upon the happening of the event which constitutes the condition. So we already know about the conditional obligations. Discuss na siya sa akong kauban kanina. So, di ba sa obligation na atay debtor nga naay obligation and then creditor nga naay rights. So, states here the acquisition of rights sa creditor and then extinguishment or loss of the creditor. So, when you say acquisition of rights is naay right ang creditor or naay acquisition ng right ang creditor upon sa ilang sabutan. The question is, when does the right happen? So, mahitabo ra nga nanay right ang creditor kung ma-fulfill, kung mahitabo na ang condition. For example, so X promised to Y na mahatag siya laptop if si Y is makapasar sa CPA examination. So, once mahitabo na tong condition or makapasa na si Y sa CPA examination, nanay obligation sa X nga mohatag ni Y og laptop. And we have sa extinguishment or loss or means resolutory condition. So, ang right sa creditor is mawala na if ang condition is already happened. So, example for that is X will let Y use his car until Y pass the CPA examination. So, mao na pod undang, dili na makagamit si Y sa car ni X once na makapasar na siya sa examination sa CPA. So that is Article 1181. So let's proceed to Article 1182. Article 1182, when the fulfillment of the condition depends upon the sole will of the debtor, the conditional obligation shall be void. If it depends upon chance or upon the will of a third person, the obligation shall take effect in conformity with the provision of this code. So, Article 1182 talks about classification of conditions as to origin. So, states here when the fulfillment of condition depends upon the sole will of the debtor, the conditional obligation shall be void. So it means if nakadepende sa debtor ang pag-fulfill sa conditional obligation, it is bawal or it is void or it is not valid because it's not fair to the debt to the other party. But states here, if it depends upon chance or upon the will of a third person, the obligation shall take effect and confirmatory with the provision of this code. It will make valid if the condition depends random like chance or the will of the third person. So we will talk about three kinds of condition. We have potestative condition, casual condition, and mixed condition. So potestative condition is a condition that depends upon the will of the contracting parties. So it is the will of the debtor and then the creditor. So munang natay potestative on the part of the debtor and potestative condition in the part of the creditor. So potestative condition on the part of the debtor, if suspensive condition siya, the obligation is void. Even if the condition is fulfilled, the obligation is not demandable. Example, D is to give C 10,000 pesos if D goes to Baguio. So, maura makahatag si D kung misi og 10,000 kung maato siya sa Baguio, si D, which is ang debtor. So, next is, if resolutory condition siya, the obligation is valid. So, example for that is, D is to allow the use of his car by C until D returns from Baguio. The next is the potestative on the part of the creditor. So here is the obligation is valid whether the condition is suspensive or resolutory. Example for that is D is to give C 10,000 pesos if C goes to Baguio, and D is to allow the use of his car by C until C returns from Baguio. Next is the casual condition. So the casual condition is a condition that depends upon chance or upon the will of the third person. So example, D is to give C 10,000 pesos if D wins the first prize in the lotto on the bet he placed this morning. So nagdepende na siya sa chance. And another example is D is to give C 10,000 pesos if X goes to Baguio. So naanay other person nga na appeal. So naanay third person. Next is a mixed condition. So is a condition that depends partly upon the will of one of the parties and partly upon chance or upon the will of a third person. Example for that is D is to give C 10,000 pesos if C will marry X. So that's it, the Article 1182. So next is Article 1183. So impassable conditions, those contrary to good customs or public policy and those prohibited by law shall annul the obligation which depends upon them. If the obligation is divisible, the part thereof which is not affected by the impossible or unlawful condition shall be valid. So, impassible condition. So, if ang obligation kuno is impossible or prohibitional or unlawful, it is not valid. Pero kuno, if ang obligation is divisible, the part thereof which is not affected by the impossible or unlawful condition is valid. So what is divisible obligation? Divisible obligation are those which have as their object a presentation which is susceptible of partial performance without the essence of the obligation being changed. If the condition or the obligation is if the obligation is divisible or can be broken into parts, the parts that aren't affected by the impossible or unlawful condition remain valid and enforceable. So we have example for that. A debtor agrees to deliver 10 boxes of apples to a creditor in 2 shipments. 5 boxes now and 5 boxes next week. However, due to a problem with transportation, the debtor can only deliver the first 5 boxes. So the debtor is still required to deliver the first 5 boxes as the part of the obligation is valid. So katong 5 ka second 5 boxes are now impossible to deliver due to the transportation issue. So this part of the obligation becomes void. So in this case, the obligation is divisible and the debtor must still fulfill the first part, 5 boxes. And while the second part, 5 boxes, is considered void due to impossibility. Then we have states here also the condition not to do in an impossible thing shall be considered as not having been agreed upon. So example is a person agrees to perform a task only if the other party promises not to do something impossible, like bringing back the dead. Since the promise is impossible, it is treated as if no condition was agreed upon. So we have kinds of impossible condition. We have physical impossible conditions and legal impossible conditions. Physical impossible conditions, these are conditions which are contrary to the law of nature. Example, X obliged himself to give Y his only house and lot if Y can make a flying study table. So it's impossible, diba? Next is the legal impossible conditions. These are conditions which are contrary to law, morals, good customs, public order, or public policy. Example, X promised to pay Y 100,000 if the latter will inflict serious physical injuries to Y. So dili na siya pwede. And that's Article 1183.
Article 1184 states that the condition that some event happen of a determinate time shall extinguish the obligation as soon as the time expires, or if it has become indubitable that the event will not take place. So this article refers to the positive condition. We can say positive condition or obligation. It means the obligation to do. So for example, Abel will give a flat 1 grade to Mr. J if he joins the fun run. So after the fun run, Abel finds out that Mr. J did not join. So Abel's obligation to give a flat 1 grade to Mr. J has been extinguished since what maning follow si Mr. J sa condition ni Abel. Next, or there might be a fortuitous event that causes the fun run will not take place. For example, ning linog or there is a fire or accident na causes na mo stop ang event. This still obligation has been extinguished kay wala man nidagan si Mr. J or wala alahos ang event. Article 1185 states that the condition that some event will not happen at a determinate time shall render the obligation effective from the moment the time indicated has elapsed, or if it has become evident that the event cannot occur. If no time has been fixed, the condition shall be deemed fulfilled at such time as may have probably been contemplated, bearing in mind the nature of the obligation. So, this article refers to the negative condition, where it states ang negative condition is an obligation not to do. So, kanya siya na article is opposite lang siya sa 1184. Where this is obligation not to do. For example, Same example ganina, Abel will not give a flat 1 grade to Mr. J if he joins the fun run. So, and in the fun run, Abel finds out that Mr. J did not join. So, Abel must have the obligation to give a flat 1 grade to Mr. J since ni follow siya sa condition. Then, next, or there might be a fortuitous event like ning linog na sad and there's might a fire or accident na itabo that causes the event to stop. Still, Abel must have the obligation to give a flat 1 grade to Mr. J since wala ni run or ni appeal si Mr. J sa fun run. Article 1186 stated that the condition shall be deemed fulfilled when the obliger voluntarily prevents its fulfillment. So, the above stated article refers to the doctrine of constructive fulfillment of suspensive condition. For example, Abel promised to Mr. J if he passed the economics test, Mr. J will have a reward, an unlimited buffet at the restaurant. So, when the day of the test started, Mr. J was poisoned by Abel. So, in that case, Mr. J did not take the test because of his condition. Pero in that scenario, Abel must have still the obligation to reward Mr. J unlimited buffet because he voluntarily prevents its fulfillment.
So let's tackle about the Article 1187. The effect of a conditional obligation. The effect of a conditional obligation to give, once the condition has been fulfilled, shall retroact to the day of the constitution of the obligation. Nevertheless, when the obligation impasses reciprocal presentation upon the parties, the fruits and interest during the pendency of the condition shall be deemed to have been mutually compensated. If the obligation is unilateral, the debtor shall appropriate the fruits and interest received, unless from the nature and circumstances of the obligation, it should be inferred that the intention of the person constituting the same was different. So it means that the effect of a conditional obligation to give, once the condition has been fulfilled, shall retroact to the day of the constitution of the obligation. Nevertheless, when the obligation impasses reciprocal prestation, that means that both parties in agreement or contract have mutual obligation to fulfill, that each party is required to perform something in exchange for what the other party provides. Upon the parties and fruits and interest during the pendency of the condition shall be deemed to have been mutually compensated. It means that the benefit that the both parties receive while waiting for the condition to be fulfilled are considered or offsets against each other. If the obligation is unilateral, it means where one only party has a duty to fulfill. The debtor, the one who must perform the obligation, gets to keep any benefits they receive while waiting for the condition to happen. However, if the nature of the obligation or the surrounding circumstances show that the original intention was different, then the debtor may not get to keep them. So, an obligation to do and not to do, the courts shall determine in each case the retroactive effect of the condition that have been complied with. So, the courts na mag-decide on case-to-case basis whether if ilan nila i-apply ang retroactive effect. So, in principle of retroactivity in suspensive condition, it is limited only to the effects of the obligation. So, for the obligation to give, once the condition has been fulfilled, it shall retroact to the day of the constitution of the obligation. The condition is only an accidental element of contract, hence the obligation is still valid even if the absence of such condition. So the accidental elements of contract means that those which exist only when the parties expressly provide for them for the purpose of limiting or modifying normal effects of the contract. For example, is the condition, terms, and modes. For example, on January 1, 2026, my mother obliged herself to give the Cartier jewelry to my sister if she passed the LPT examination that will be released on December. However, my sister passed the LPT examination by operation of law, as if that my sister owns that Cartier jewelry in the beginning of January. In obligation to do or not to do, the court is empowered to determine retroactive effect of the suspensive condition that have been compiled with. So this rules is also applicable to obligation to do or not to do with the salutary condition in accordance with Article 1190, paragraph 3. So the retroactive effect as the fruits and interest in obligation to give. In terms of reciprocal obligation, there is no retroactive effect. The fruits and interest during pendency of the condition shall be deemed to have been mutually compensated. For example, the person A agrees to sell a car to person B for 100,000 pesos. In return, person B agrees to pay the 100,000 pesos to person A. In this case, person A and person B have a reciprocal obligations. Person A is obligated to deliver the car and person B is obligated to pay the agreed amount. These obligations are interdependent, meaning that neither party is required to fulfill their part until the other party fulfill their part. If one of the party fails to perform, the other party may not be required to fulfill their own obligation, which is typically a reciprocal obligation. For example, if person A fails to deliver the car, person B does not need to pay. So in terms of unilateral obligation, there is no retroactive effect. The debtor shall appropriate the fruits and the interest received, unless from the nature and circumstances of the obligation, it should be inferred that the intention of the person constituting the same was different. Unilateral obligation is usually gratuitous. For example, a person A, which is the donor, agrees to give the person B, which is the recipient, a gift of 1,000 pesos. So, person A has a unilateral obligation to give the 1,000 pesos and person B has no corresponding duty to give anything in return. So, person B is not required to do anything and the obligation rests entirely on the person A to fulfill. In this case, person A is free to withdraw the gift before it is delivered, and person A does deliver the gift. They cannot retroactively claim anything back unless specified in terms of the gift or inferred from the nature of the gift. So that's all for Article 1187. So that's all. So next, let's tackle about the Article 1188. The creditor may, before the fulfillment of condition, bring the appropriate action for the preservation of his right. The debtor may recover what during the same time he has paid by mistake in case of suspensive condition. So in terms of the right of the creditor before the fulfillment of the condition, the creditor may, before the fulfillment of the condition, bring the appropriate actions for the preservation of his right, while the rights of the debtor before the fulfillment of condition, the debtor may recover what during the same time he has paid by mistake in case of suspensive condition. If the debtor paid with knowledge of the condition and not by mistake, he impliedly waives the condition, therefore, he cannot recover. So in this right, it implies the solution in indemnity. However, if the debtor paid with knowledge that the condition did not happen, the debtor can recover, otherwise the creditor will be unjustly enriched and expense of the debtor. So that's all for Article 1188.
According to Article 1189, when the conditions have been imposed with the intention of suspending the efficacy of an obligation to give, these are the following rules to be observed in cases of loss, deterioration, or improvement of the thing pending the happening of the condition and obligation to give. So what is loss? A thing is lost when it, number one, when it perishes or when it disappears completely. Number two, when it goes out of commerce or when it's not tradable anymore in the market. Number three, when it disappears in such a way that its existence is unknown or it cannot be recovered. So, the number one rule is if the thing is lost without the fall of the debtor, the obligation shall be extinguished or shall be put to an end. An example for that is X obliged himself to deliver his only car to Y if Y passes his board examination. However, before the release of the result of his board examination, the car was lost through an earthquake. An earthquake is a fortuitous event, so the obligation will be put to an end. It will be extinguished. Number two, if the thing is lost through the fault of the debtor shall be obliged to pay the damages. An example for that is X obliged himself to deliver his only car to Y if Y graduates. However, before the date of graduation, said car was totally destroyed when it fell to a cliff while X was driving it. The result of the police investigation showed that X was drunk when the incident happened. So, X will be liable for the damages that he caused because DUI or driving under the influence of alcohol is a fault or a negligence. Number three, when the thing deteriorates without the fault of the debtor, the impairment is to be borne by the creditor. So by deteriorate, it means that when a condition worsens. An example for that is X bound himself to give Y his only car if Y passes his subjects the second semester. So after 4 months from the start of the semester, Y passed the said exams. Obviously, naturally, a car deteriorates through wear and tear. The question now is, who will bear the decrease in value of the car or the depreciation of the car after 4 months of use? It will be Y because the depreciation is without the fault of X since it is a natural occurrence. Number 4, if it deteriorates through the fault of the debtor, the creditor may choose between the rescission of the obligation or the cancellation of an agreement. Rescission means the cancellation of an agreement, and its fulfillment with indemnity for damages in either case. Example for that is on February 14, 2023, X bound himself to sell his only car to Y if Y passes the exams. Y passed the said exams. However, from February 14 up to April 2023, the same year, X used the car with negligence by choosing to pass through the rough gravel roads instead of passing through the cemented roads. In this case, Y can choose specific performance or, in the alternative, rescission with indemnity for damages in either case. Number 5. If the thing is improved by its nature or by time, the improvement shall inure to the benefit of the creditor. Example, on May 1, 2022, X bound himself to give his only parcel of land to Y if the latter passes his exams. Y passed the said government examination. A land normally increases in value through the passage of time. Thus, in the present case, the improvement shall be benefited by Y. Number 6. If it is improved at the expense of the debtor shall have no right than the granted to the usufructuary. So what is usufructuary? It is a person who has the right to the benefit of another person's property. Example for that is on February 14, 2023, X bound himself to give his only car to Y if the latter passes his April 2023 career examination. Y passed the said government examination. However, from February 14 up to April 2023, X introduced improvements in the said car, like repainting of the entire body of the car because of deterioration, change of the major parts of its engine because of leakage of oil, and putting a pink leather cover in the seats. In the above cases, X will exercise the right of usufructuary. Hence, he can remove the leather cover of the seats. Also, he has the right to be indemnified on his expenses in the repainting of the car and the change of the major parts of the engine, as these are necessary expenses. So, if X made damage to the car like scratches, he may set off any of these damages against the improvements. So there are two rights of the usufructuary. The first one is the usufructuary may make useful improvements or expenses for his mere pleasure on the property, as long as he does not alter or he does not make any altercation in its form or substance. And he also has no right to be indemnified. He may, however, remove such improvements if it's possible to do so without damaging the property. Number 2 is the usufructuary may set off the improvements he may have made on the property against any damage to the same. So, according to Article 1190, when the conditions have for their purpose the extinguishment of an obligation to give, the parties, upon the fulfillment of said conditions, shall return to each other what they have received. In case of the loss, deterioration, or improvement of the thing, the provisions which, with respect to the debtor, are laid down in the preceding article shall be applied to the party who is bound to return. As for the obligations to do and not to do, the provisions of the second paragraph of Article 1187 shall be observed as regards the effect of the extinguishment of the obligation. Effect on fulfillment of resolutory condition and obligation to give. The parties, upon the fulfillment of said conditions, shall return to each other what they have received. Example, X obliged to give his land to Y under a condition where Y does not go to the pub under 4 months. So, if Y goes against the condition X has given him, the obligation will as if not constituted at all. Effect on fulfillment of resolutory condition in obligation to do and not to do. In obligation to do and not to do, the courts shall determine, in each case, the retroactive effect of the condition that has been complied with. And that's it for Article 1190.
So let's proceed to Article 1191. So Article 1191, it states that the power to rescind obligation is implied in reciprocal ones in case one of the obligors should not comply with what is incumbent upon him. The injured party may choose between the fulfillment and the rescission of the obligation. With the payment of damages in either case, he may also seek rescissions even after he has chosen fulfillment if the latter should become impossible. The court shall decree the rescission claim unless there be just cause authorizing the fixing of a period. This is understood to be without prejudice to the rights of third persons who have acquired the thing in accordance with Article 1385 and 1388 with ENDA mortgage law. So, Article 1191 of the Civil Code of the Philippines says that if one person in a contract does not do what they promise, the other person can cancel the contract. The injured party can also ask for damages, money, or compensation because of the broken promise. However, the court might give the person who failed to fulfill their obligation a chance to fix their mistake instead of canceling the contract right away. So, what is rescission? So, rescission means canceling a contract and treating it as if it never happened. When a contract is rescinded, both parties must return whatever they received. I have here an example. So let's say A agreed to sell his car to B for 500,000 pesos. B paid 300,000 pesos advance, but A never delivered the car. So in this case, B can file for rescission, which means A must return 300,000 pesos to B, and B will no longer own a right to the car. So, what is reciprocal obligation? Reciprocal obligation are those where both parties have duties to each other. One party's performance depends on the other. Here is an example. In a sale, the seller must deliver the item and the buyer must pay for it. If one party does not comply, the other party can seek legal remedies. So, general rule for rescission: if one party does not fulfill their obligation, the other can rescind the contract. However, rescission is only allowed if the breach is substantial. Example: X agreed to sell land for Y for 3 million pesos. X signed the deed of sale and Y paid 200,000 pesos in cash and issued a 2,800,000 check. However, the check bounced due to insufficient funds. Since Y failed to pay the full price, X can rescind the contract and take back the land. When rescission does not apply, not all cancellations are rescission. So here an example. The National Housing Authority bought land from B and A, but later found out that some of the land was in a landslide-prone area. They canceled part of the contract. They canceled part of the contract. This is not rescission under Article 1191 because B and C did not breach their obligation. So, what is mutual restitution? Mutual restitution is when a contract is rescinded, both parties must return what they received. Example: A and B made a deal where A supplies goods to B for 1 million pesos. If A fails to deliver the goods, B can ask for rescission. If A already received the money, he must return to it. Alternative remedies of injured party. Fulfillment of the obligation with damages. This refers to specific performance. So, example of specific performance. If X agreed to sell a car for Y but refuses to deliver it, Y can file for specific performance to force X to deliver the car. So, judicial versus extrajudicial rescission. So, judicial rescission needs a court decision, while extrajudicial rescission can happen without court action if the contract allows it. So Article 1191 ensures fairness in contracts. If one party does not comply, the other party has the right to seek fulfillment or cancellation. However, rescission only applies in cases of substantial breach. When a contract is rescinded, both parties must return what they receive. So let's proceed to Article 1192 of the Civil Code. Article 1192 states that in case both parties have committed a breach of the obligation, the liability of the first infractor shall be equitably tempered by the courts. If it cannot be determined which of the parties first violated the contract, the same shall be deemed extinguished, and each shall bear his own damages. So, Article 1192 of the Civil Code. This article tells us what happens when both parties in a contract fail to fulfill their obligations. So, there are two situations under this article, and I will explain them. Situation 1. The first infractor is known. The first situation is when we know who broke the contract first. One party violates their obligation first. The other party also violates the contract afterward. So what happened? The first person to break the contract is still responsible, but the court will reduce their liability because the other party also failed to comply. So here's an example. Let's say Anna agreed to deliver 100 sacks of rice to Ben on February 1, and Ben agreed to pay 100,000 upon delivery. But Anna did not deliver the rice on February 1, and Ben refused to pay even when Anna tried to deliver it later. So, Anna was the first to violate the contract. But since Ben also failed to pay, the court will reduce Anna's liability. This means Anna may not have to pay as much in damages as she normally would. So, second is situation 2. The first infractor cannot be determined. So, the second situation is when we do not know who broke the contract first. Both parties violated the contract, but we cannot tell who was at fault first. So, what will happen? The contract is considered cancelled or extinguished. No one can demand fulfillment or ask for damages. Each party must bear their own losses. Example. Imagine Carlos agreed to sell a laptop to Diana for 50,000 pesos. Carlos failed to deliver the laptop on time. Diana, thinking the deal was off, spent her money on something else and refused to pay later. Since we do not know who broke the contract first, the contract is cancelled, and neither can demand anything from the other. So, Carlos keeps the laptop and Diana keeps her money. So, Article 1192 applies when both parties fail to fulfill a contract. This law ensures fairness and prevents unfair advantage when both parties fail to fulfill their obligations.